A debate that's been at the center of legal profession for over 10 years in India reached finality this week. The Supreme Court of India pronounced its judgment on the entry of foreign lawyers and what they can or cannot do in India. In its ruling, the Apex Court seems to have widened the scope of practice of law compared to what the Madras High Court had laid down 6 years ago. Shivani, Saxena and Arpan Chaturvedi speak to the stakeholders to understand the implications of the Supreme Court ruling.
Back in 2009, the Bombay High Court had interpreted the Advocates Act and held that foreign lawyers cannot practice any law within the territory of India, whether litigation-related or non-litigation-related mandate. 3 years later, the Madras High Court came to the same conclusion that foreign lawyers and law firms cannot practice in India unless they comply with the Advocates Act and the Bar Council of India rules. But the Madras High Court did allow foreign lawyers to visit India temporarily and advise on foreign law aspects. This is now called the fly-in and fly-out rule. The Madras High Court had also permitted foreign lawyers to conduct arbitration relating to international commercial disputes, to set up BPOs for providing ancillary non-practice related services like secretarial support or transcription service.
Several years ago, some of these foreign firms had actually set up offices in India and were professing to be practicing foreign law and not Indian law. And also clearly they were not doing any kind of litigation work. And that did cause some unease in terms of what this meant and how this would go forward.
There were a few foreign law firms who wanted to establish offices in this country, and therefore they had taken approvals from the Foreign Investment Promotion Board, FIPB, to establish liaison offices in this country so that they can conduct liaison activities with their clients in this country. It is the establishment of those liaison offices which actually triggered the entire litigation, leading to the Bombay High Court indicating that no legal services whatsoever can be rendered by a non-lawyer or a person who is not enrolled as a lawyer under the Advocates Act. Whereas under a similar circumstance, the Chennai High Court indeed agreed that lawyering is a reserved activity for lawyers under the Advocates Act.
This week, the Apex Court not only confirmed the rulings of the Madras High Court and the Bombay High Court, but experts say it has perhaps made the access of foreign lawyers more difficult. One, by keeping the question as to what will amount to practice of law open, and two, by imposing restrictions on foreign lawyers that they will only be able to advise on the foreign law aspect of Indian deals.
Foreign lawyers and law firms play a significant role in structuring, negotiating, and drafting documents in cross-border deals and commercial transactions having foreign implications. While lending an ear to this issue, the Madras High Court had permitted foreign lawyers to visit India temporarily on a fly-in, fly-out basis for giving advice on foreign law. But the Apex Court has made matters worse for them by holding that regular visits may still qualify as practice of law and therefore be barred. What will be deemed as practice of law would be determined on a case-by-case basis, and the Bar Council of India and the Government of India can frame rules to regulate this.
Supreme Court has given a very broad definition of what amounts to practice of law. Therefore, whether it is litigation work, whether it is transactional work, whether it is Indian law, whether it is foreign law, you can't establish your practice of law in India and say that I am only practicing UK law or US law. That is prohibited as per the judgment of the Supreme Court.
Number one, they cannot set up an office in India, that is clear. That was clear from the Madras High Court judgment as well. I think what is sought to be added is that it cannot become like a practice of law. And they have cited some judgments of other countries where merely saying foreign law can be practiced in a different jurisdiction may not be completely accurate, because there may be a lot of elements of the Indian law that also become relevant in terms of what is being done, whether it's a transaction, advice, etc. So yes, there is more clarity now, as to whether coming once a year, twice a year, 5 times a year, different partners of the same firm coming each month, each week. The principle, I think, is being laid down. and the intent obviously is that it is abided by in the spirit in which it has been stated. There is not a regular occurrence that they continuously have people on the ground over here, sort of continuously advising, albeit not with an office, with a signboard outside.
The second modification that the Supreme Court made to Madras High Court order relates to the arbitration practice by foreign lawyers in India. It is a common practice for foreign lawyers to represent foreign clients in commercial arbitration conducted in India. These lawyers are not just involved in conducting arbitration, but also negotiating and drafting documents that relate to such arbitration. Noting this requirement and the intent of the government to popularize Indian commercial arbitration, the Madras High Court had allowed foreign lawyers to represent clients in international commercial arbitration for disputes arising out of commercial contracts. The Apex Court has tightened this framework to say that the ability of a foreign lawyer to represent clients in arbitration proceedings in India is not absolute. It will be subject to the rules of institutional arbitration, the Arbitration Act, and governed by the code of conduct that applies to legal profession in India. Here too, the Apex Court said that Government and Bar Council of India can frame rules to cover the gaps.
What the Supreme Court has recognized is that internationally also, arbitrations which are conducted, especially cross-border arbitrations, may even have a foreign law as the applicable law. It is usual, I would say, common usual, that advocates from India can go and appear before arbitral tribunals in many countries. Also, given the fact that India is looking to increase its international relationships in terms of business, the expectation would be, on that count at least, foreign lawyers should be allowed to come and appear. But what the Supreme Court has said is it is not an unfettered right. They are still bound by the code of ethics that apply in India, and they're also bound by rules of any institution that is governing the arbitration.
I don't think we should look at what has happened from colored glasses. It's not that lawyers are not allowed at all or international lawyers have been completely disbarred from international arbitration. The Supreme Court is completely right when it says that foreign lawyers are allowed to arbitrate in this country provided the rules of arbitration of the institution permit such appearance, and therefore I don't think that will make any difference or any negative difference in the way arbitrations are conducted in this country. I'll give you an example. A lawyer flying from Delhi to Singapore appears in an arbitral proceedings before the Singapore International Court of Arbitration and comes back because he follows the rules of arbitration or rules of that institution. Similarly, a foreign lawyer can fly into this country and, subject to the rules of arbitration governing him, appear, conduct the arbitration and fly out.
The ICC court very much welcomes the judgment by the Supreme Court of India in this matter, in that it provides some much needed clarity on a matter that has been pending for quite some time now. It is now clearer that foreign counsel can represent clients in arbitration hearings that are taking place within India when the dispute is an international commercial arbitration case. And of course, that is an area of marked interest for the ICC court and ICC arbitration users worldwide. The Supreme Court judgment, of course, does come with a caveat. It does impose certain conditions, namely that the arbitration needs to be administered by an institution and that the parties must have agreed under institutional rules. That would not be a problem under the ICC rules of arbitration. Or alternatively, that the dispute, that the case is being conducted under the Indian Arbitration Act. At the same time, the ICC court notes that and welcomes the encouragement that the Supreme Court judgment passes on to the India Bar Council in ensuring that rules framed with regard to conduct by foreign counsel within cases heard in India should be developed, and the ICC court is very much ready to lend support and assistance in that exercise as well. So overall, this is a positive and encouraging development.
The doors to globalization in India are only getting wider and wider, be it because of the FDI norms that are more lenient or the relaxed foreign exchange policy. But the legal services industry is probably the only exception. Now, foreign players have taken deep interest in the cross-border transactions that involve India. But given the context of the judgment that we discussed today, experts are of the view that their position is neither worse nor better off after the judgment. But it has rolled the ball into the government's court. And if the government is serious about opening up the legal services industry, then it will have to bring in new laws or amend the existing one. This is Shivani Saxena for Bloomberg Quint, Mumbai.
Well, since the Apex Court has left the rule-making power in the hands of the Bar Council, it would only be fair for the Council to frame clear guidelines for foreign practitioners and not leave the question of practice of law open to interpretation.